Hi guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us yet again for another one of our, one would say, updates. The Senzobewa trial, they're still on recess. The defense is preparing for their defense, gathering up their witnesses. So while they do that, in the meantime, how about we entertain other stories? Yes, we had already started with the deliberation of Shadrach Sibiya's court case. He had said that he wants to go back to work, and he was fighting very, very hard, family, very, very hard to go back to work. I've never seen anybody who has been told to stay at home, their security not taken away, all their benefits and privileges not being taken away, and they fight to go back to the office. That's how much he loves his job. I saw other people saying that maybe at home he's that miserable that he just can't. He just wants to go back to work. That's the passion he has for his work. Better yet, none of us have ever seen anything like this. I don't think I've ever seen anything like it before. It was so strange and peculiar. I listened to the court case last week, Friday, and I couldn't quite fathom it. I couldn't quite break it down. I didn't understand what was happening, because when it came to the arguments that he brought forth, they were all very strange. I even remember mentioning it in yesterday's live about that whole situation where he called it a public power dispute. Yes, that's what it was called, and it was a strange case, in my opinion. But it was all about powers that, certain individuals don't have certain powers to tell other people or bodies of work what to do. The example that I remember being quoted by Mr. Anonymous was that maybe coming from a national office, you don't have the authorization to go and fire people at a municipality level or something like that. Anyway, that was my brief understanding of it. But today, news came out, or rather yesterday by the time that I will be premiering this video, that the Deputy National Police Commissioner for Crime Detection, Lieutenant General Shadrach Sibia, has lost his High Court bid to overturn the stay-at-home he received in July and returned to work. So yes, he has lost that bid. It was an urgent application that he had made. And remember how it started with very dramatic affidavits, with Sibiya filing his affidavit and Masemola responding back with his own affidavit, and all these gatas that were revealed there. But a sense that we got, or that I got while I was deliberating those affidavits, was somewhat of a sense of really General Sibiya undermining the position of the National Commissioner, Fanny Masemola. Nobody's saying that Fanny Masemola is a saint, because I've been seeing a lot of those for people who really don't like him. They're saying that, oh, he's not a saint, he also has his own shenanigans. Okay, we'll wait for the receipts. When the receipts come, we mean proper receipts. We don't mean fabricated ones or ones that just don't make sense. We'll deliberate on them, of course, should they come up. But it felt like he was being undermined. His position as the National Commissioner was being undermined, in our opinion, or my opinion, by General Sibiya. He was saying that he didn't have the powers or the authority to tell him to stay at home, which was very strange, because he acted as a National Commissioner and he has been appointed as the Deputy National Police Commissioner. So why doesn't the National Police Commissioner have authorization to either suspend you or tell you to sit at home while an investigation is being conducted? Right. What he should be focusing on is rebutting those allegations that are against him. That was what I thought. When you are told to stay at home, what you need to think about is, how am I going to get out of this mess? How am I going to prove this case that is against me is false or fabricated or whatever he's saying it is? But that was not the case. Instead, he wanted to go back to work. And this is what as he was fighting to go back to work, the 121 dockets that he had gotten him into this trouble to begin with were now returned to the political killings task team, which is their original home, instead of gathering dust there at the head office in Pretoria, apparently, allegedly. So the National Police Commissioner General Fani Masemola ordered Sibia to stay at home pending an investigation after KwaZulu-Natal top cop Lieutenant General Nhlanhla Mkhwanazi implicated him in allegations that the country's criminal justice system had been captured. Sibia then lodged an urgent application in the Gauteng High Court in Pretoria challenging Masemola's order, which he labeled as a disguised suspension. Disguised suspension. Honestly, in my opinion, I did not care whether it's a suspension or a stay-at-home instruction, whatever it was. It didn't matter to me, because I saw nothing wrong with a senior telling someone who's a little bit, below him to say there are damning allegations against you. I think it's best you sit at home while we investigate what these allegations against you are about. Do you understand what I'm saying? I mean, that's normal procedure for any job. Or rather it should be. But in a country like South Africa, where you are seeing now people who bring up allegations against people, whistleblowers to be specific, being taken out, you then begin to wonder, Uguti, what is what? The lines become very blurry. You don't know what is the law and what's not anymore, unless if you are a lawyer yourself and you're going through all these laws on a daily basis and researching. So the case was heard by a full bench last week and dismissed with costs on Tuesday. Now, this was one of the requests that were made by General Sibia himself, that he wanted a full bench. He wanted 3 judges. It's not a full bench. I don't know what they call 3 judges, but it's a bench either way, of judges to sit over his case. I don't know what the aim was, or he felt like if it's just a single judge, they're not going to hear his case properly or something. And I also found out last week that having a judge of 3 is quite an expensive exercise and request, but he did it anyway. And that kind of alarmed me, because I was thinking maybe he's demonstrating the confidence that he understands the law and how General Fani Masemola is wrong in the activity that he did. He's that confident that he's saying if there's 3 judges, then there's no way they can not rule in a way that is strange. I don't know. Guys, you will tell me what you think are behind that whole situation where he requested 3 judges. It was all very strange. And the court found, among other things, that Sibia's legal team attempted to convert or elevate the stay-at-home instruction to a suspension, and it's not supported by evidence. Those were some of the arguments that were made in the case. Well, I had to go back and jog my memory. As I was listening to it last week, I did not take down notes. I was just listening. But then I had to refresh my memory before I came and talked to you guys about this case, to say, you know what, some of the arguments were just peculiar and strange. They were quite unusual, right? So Lieutenant General Shadrack Sibia last week in court said that the order to stay at home that he was slapped with in July looked like a precautionary suspension and smelled like a precautionary suspension, and probably for General Sibia even tastes like a precautionary suspension. And they also said that he wanted the court to nullify Masemola's order so that he can return to work and interdict him from proceeding with further disciplinary action pending the finalization of the Madlanga Commission established on the back of Mkhwanazi's claims. A full bench heard the case also on Wednesday, and Sibia had previously characterized the stay-at-home order as a disguised suspension. Masemola denied this, but Sibia's counsel, Advocate Kamil Premhid, persisted with the argument, maintaining that his client was not an affordable his client was not afforded the opportunity to make representations beforehand, and that this violated the police's disciplinary regulations. He also went on and added that if the source of the power doesn't permit the administrative power in question, then everything that follows tainted. There was a moment there where the judges were asking questions, and I was so impressed, guys. I don't want to lie with the questions that they were asking. I'm not saying that they were wrong for asking questions. We've already heard from the other judge in the other court case telling us that there's nothing wrong with that, and we have seen in the past judges asking questions. But usually when they ask questions, you can read that which side are they on, or their judgment is crafting towards which direction. With these judges, I don't want to lie, it was quite difficult to tell. I found myself not being sure. I thought maybe General Sibia has a case. Maybe his case is strong or something. But they were asking quite interesting questions, especially for us laymen who are not familiar with court process and laws and all of those things. We just wanted to understand what is wrong with what Masemola did. And their questions were seeking to get to the bottom of that, for them as well to understand clearly what was the procedure that should have happened and why it did not happen. And they were asking those clarity seeking questions, and they were not doing what that other judge does in that other case. Instead of hinting to witnesses and really strange things, they were not doing any of that. They just wanted to understand what the argument of General Sibia's lawyer was, where he was going. It was very interesting, guys, to watch.
The first point I'm going to make is an important conceptual framework point. And that is to ask this court to engage this matter as one about the exercise of public power and not an unfair labor practice. And the reason we say that is because Lieutenant General Sibia places in issue the power of the National Commissioner to deal with him in the way he has been dealt with. Now, Justice Davis, in response directly to the point you put to me, the reason that the subsequent notice in the supplementary affidavit doesn't render the first principle prayer moot is because the delivery of that notice confirms that the objection taken by Lieutenant General Sibia at the start of the proceedings is good. And it's good.
The prayer says that the second respondent's decision to direct the applicant to stay at home pending an investigation be declared as unlawful, void, and no force or effect. Now, whatever argument you might put forward regarding power or not, that notice or that instruction has been overtaken by events. Hence my question, will then the relief based on something which is no longer in effect is in effect moot?
No, with all due respect, that's not correct. And the reason it's not correct is because of the relationship between the first decision, which is what was the subject matter when the launch of the proceedings happened, and how the development of the second notice to it, when I can, bearing in mind what you've said about mootness. But I'll just say two things quickly in response, if I may. The first one is, Justice Davis, you'll be aware of Justice Wallace's decision in the Supreme Court of Appeal, where the Supreme Court of Appeal in the Al-Bashir litigation indicated that even where a matter may be so-called moot, there are compelling interests of justice reasons as to why the court may nonetheless make a declaration. And the point that I will make is that this court should make the declaration for the reasons that I advance.
Yes, but that is a different argument. That involves the concession that the relief is moot.
No,
You still want the decision.
yes. Correct. So what I'm saying is I'm addressing you in both respects. In the first instance, I'm saying I'm not sure I agree it's moot, and therefore...
Yes, but that is a different argument. That involves the concession that the relief is moot.
No,
You still want the decision.
yes, correct. So what I'm saying is I'm addressing you in both respects. In the first instance, I'm saying I'm not sure I agree it's moot, and therefore it renders, and for the reasons I'll develop, the decision is unlawful. But to the extent it is moot, then the Al-Bashir principle applies. That's, I think, where we are debating, Justice Davis, if I understand that correctly.
A few moments later.
That parallel process and the Commission, and given that there are questions about General Masemula's independence, his conflict of interest, his mala fides, and so on, that there is no principal reason as to why that parallel process should be allowed to proceed in circumstances where the Commission will do the disciplining in terms of the terms of reference that the President gave to it. Because one of the issues that the President says that the Commission must investigate is whether or not disciplinary measures should be taken against people implicated in those allegations. In other words, on General Mkwanazi's version, my client, Lieutenant General Sibiya. And that's why the Commission must be allowed to perform its function without interference by the National Commission. The third, I'm sorry, Justice Moshawana.
Just for my understanding, you make reference to the exercise of public power.
Yes.
Is my understanding correct that you are now suggesting that the decision to stay at home amounts to an exercise of public power?
Yes, that is the suggestion, correct.
And secondly, the fact that, or the issues that are to be investigated in the commission are issues that did not arise only the other day.
Yes.
Arisen many moons and years ago.
Yes.
Now, on the papers of the report was alleged or suggested that certain instructions were given and those instructions were fulfilled. How is that connected to the judicial commission?
Beg your pardon, Justice Moshawana, can you
How is the allegation of misconduct that is placed at the door of the applicant related to the judicial commission of inquiry? Taking into account that it investigates matters of public interest that have been many years ago.
Yes. 001-63.
A few moments later.
So that's the point I'm making with all due respect. But in any event,
Sorry, Counsel.
yes, my lord.
Unless if my reading of the papers is not correct, we know as a matter of fact that they want that instruction to stay at home. And we know that the applicant is actually questioned that on two pages, legality and terms of the power.
Yes.
But the issue around or from the paper, the National Commissioner says the following: I issued a particular instruction,
Yes.
and that particular instruction was not followed.
Yes.
Now, from an employer and employee,
Yes.
that appears to be a case for insubordination on the facts
Yes.
as alleged.
Yes.
And hence, I needed to make a connection between what the Judicial Commission is going to investigate
Yes.
and these allegations
Yes.
that are placed before the applicant.
Yes.
For me, I'm struggling to make a connection between the two, but perhaps you can make your submission to make me understand what then is the relationship. When it goes to what my brother asked, that is there a suggestion that if the National Commission issues an instruction, a lawful order, and it is not complied with,
Yes.
that would prevent the National Commissioner to take disciplinary steps.
So, Justice Moshawana, if you've got 001-64 in front of you, we were talking about that a short while ago, you will see at the top of the page, paragraph 2.2 refers to suppression or manipulation of investigations. Does your Lordship have it?
No, still 2.2.
2.
Yes.
Suppression or manipulation of investigations.
Past investigation.
Yes. But the point that I'm making is that to the extent that it becomes a question of compliance with General Masimula's instruction about what to do with ongoing investigations or not to do with ongoing investigations, that clearly falls within the subject matter of the Commission of Inquiry. The point that I'm making, and perhaps this is where the disconnect has arisen, so let me take it in two parts. The point that I'm making is that before we can even get into a labor type of analysis of is this a fair practice, has the charge been adequately demonstrated, is the charge sheet specifically detailed, and all those kinds of wonderful things, we have to go back to the source of the power. And if I can demonstrate that there's no source of the power, then with all due respect, it doesn't matter whether there is some currency to General Masimula's allegations or there aren't, because if I can demonstrate that the way in which he sought to discipline fell outside the disciplinary regulations, then as a matter of the rule of law, that's gone. And so insofar as the notice of motion is concerned, you'll know that's my prayer too. Now, let's talk about then the intersection between this 2.2 and the Commission's mandate.
A few moments later.
And what Lieutenant General Sibia says in response to that is, hold his process. Let me go to the Commission. They are independent. They are neutral. They are not implicated in the way that the papers demonstrate Lieutenant General Masimula is.
Is your argument, yes, he generally has the power because he's implicated, he may have exercised it, or what is the argument? Because you say, before we look at what he says, look at what he's involved in and what he's implicated in. But I don't understand the legal logic or the logic of that. Does he have the power or doesn't he have the power? Or you say he has the power but he shouldn't exercise it because he's implicated?
Second, not first.
The second one. So there is the source of power.
No, the source...
The source of power should not be exercised in this instance.
Yep.
Well, that's why I want to understand. So there are two things. So the one thing is there is the source of power. If he'd not been implicated, not been mentioned or any of this, then he could have done it.
Yeah, that's correct. I accept that. I accept that.
He has the power to discipline.
He has the power to discipline, but the discipline has to comply with the regulations. And if I can show you that there's no stay-at-home power in the regulations, then the order to stay at home is unlawful, in the same way that I've been debating with Justice Moshawana. That's the point. But I think this is the important...
I'm now more confused. I want to understand, and I think I understood the point raised by my brother to be the following. He has the power, but because he's an implicated person, he cannot exercise that power. And you seem to have conceded that that is the position.
No.
Yes.
Can I?
Now it seems in your follow-up, you make a submission that he doesn't have the powers arising from the regulations. So in other words, his power.
Let's go to page 001 of the notice of motion, please.
Can I just find out to the source of that power? Because my understanding from your submissions was that he does have the power, but
As prescribed by the regulation.
in terms of the regulations, those powers were exercised wrong.
Correct. Unlawfully. Yes, that's right. So why that? So if we can just go to page 001-3 at prayer 2 of the notice of motion. What my lady presiding has just engaged me on is that prayer, which is if he didn't have the power to issue the stay-at-home order, then it's unlawful and it falls to be set aside or not implemented in the terms set out there.
So that is pretty much the background of the case and what was happening last week and all those arguments. It took 5 hours like a typical court case, but I think what was making it heavy was the jargon and the English there for me. It wasn't a typical criminal case at all. It was a different type of case, and he said it's not a labor dispute, the legal representative of General Sibia when he started, and he called it that public power type of case. So now we are going to find out exactly what happened when it came to the judgment that the 3 judges made today. Or rather yesterday, now as I'm sitting at this time, yesterday. Those decisions, those beautiful, kind of sensible in my opinion. We're going to go through the judgment. If you can bear with me, guys, we have to go through that judgment. Oh, it was so wonderful to read. So the instruction was neither seen as nor implemented as a suspension. So the instruction did not impact on Sibiya's remuneration, employment, or security. The bench, comprising of judges Norman Davis, Nomonde Mqebisa Tusi, and Graham Mushwana. Sibiya had further argued that were it not in fact a disguised suspension, the order was not provided for in the SAPS disciplinary regulations, and Masemola therefore did not have the power to issue it. Masemola's position, however, was that he was not acting in terms of the disciplinary regulations, but rather the SAPS standing orders and the Constitution's provision that he must exercise control over and manage the police, and the bench found with him. So the fact that the disciplinary regulations did not make provision for such an order does not mean that such an instruction by a senior officer to a subordinate cannot be made. The judges said, we therefore conclude that the instruction was not unlawful. Right? Sometimes it feels like iti abahladai. I'm like, whenever there are damning accusations against you at a place of work, the person who's above you or your supervisor will come up with a way to mitigate the process, right? Sometimes you will be suspended until further investigations are conducted, and then you're told that's a normal, right? That's a normal working condition. So at the SAPS, it seems like there's a battle of powers or something like that. And now I'm like, can you believe I found myself second guessing whether the decision to suspend him was right or wrong in the middle of all of these chaos? At some point I doubted it. I'm like, why does he have so much confidence to make all these requests, this urgent application? Maybe he has a case, but turns out the judges are agreeing with the rest of us, or with the rather people that are in normal working conditions, to say that the instruction was not unlawful. Hey, the bench agreed with Masemola's position that the stay-at-home instruction was suitable, necessary, reasonable, relevant, rational, and proportional under the circumstances, and found the issue was in any case mute or subject to debate, dispute, or uncertainty, with Sibiya having now received notice of his intended suspension or temporary transfer. So the judgment also said that it rejected Sibiya's argument that Masemola was undermining the work of the Commission of Inquiry, which has now been established to probe Mkhwanazi. In his submissions, he had also said that Masemola was undermining the commission. And Masemola has said countless of times on all of these various media interviews that he's done that he's not undermining the commission. He respects the commission, but he would like for the work of the police to continue as the commission also is happening. That's all. He's never given any hostility towards the commission. I didn't pick it up. I didn't pick it up at all. But in the case, Sibiya was saying that he is hostile towards the commission. So the judges rejected that argument, that Masemola was undermining the work of the commission inquiry. At the center of Mkhwanazi's claims, it is the disbandment of his political killings task team, which he says came on the back of meddling from executives and was effected by Sibiya. He has further accused Sibiya of removing some 121 dockets from the team and leaving them to gather dust in the interim. In his papers, Masemola said that the disciplinary process was focused on allegations that Sibiya disobeyed his instructions in these respects, while the commission was looking at the merit or the lack thereof of Mkhwanazi's claims, and began the bench agreed. Simply put, the disciplining or disciplinary of Sibiya and the work of the commission are two different things. even if Sibia's motive for having disobeyed an order may be of interest to the commission, it said in ordering costs against Sibia, meanwhile, the bench found that he had made overbroad and unfounded allegations to the effect that the commissioner was contemptuous of the proposed commission. Now, to say that he was contemptuous, let me look up contemptuous. They're saying that contemptuous means that, yes, feeling or showing hate or deep disapproval. So this is what he was accusing Masemola of being, of showing, this hate and disapproval of the proposed commission. So he said that the making of such allegations without foundation amounts to vexatious litigation. Vexatious, they're saying it means that he's causing or tending to cause annoyance and frustration or worry. So they're saying that the making of these allegations to say that Masemola is not okay with the commission and that he is finding the commission to be basically annoying and rather a waste of time. Okay, we have to also go through the judgments. You know me and my full judgment. So I love the coverage that was done by Sunday World because it went more into deeper detail to understand the judgment. I feel like a person who was writing this had the judgment right in front of them, and like me and my style of reporting, I don't like leaving a lot of things out. But yeah, this is as comprehensive as I could get it. According to the court, they are saying that the stay-at-home instruction was neither unlawful nor a suspension, Davis stated. So Davis is the legal representative of Fani Masemola. The state, no, it's not. He's one of the judges. My apologies. He's one of the judges. In the judgment, it was written that the stay-at-home instruction was suitable, necessary, reasonable, relevant, rational, and it was proportional under the circumstances. Okay, the court emphasized that commanders could issue operational orders as circumstances demand, even if the disciplinary regulations do not explicitly codify them. The fact that the discipline regulations do not make provision for such an order does not mean that such an instruction by a senior officer to a subordinate cannot be made. That right there is where they have me. And I'm like, in normal circumstances, when you are in a work environment and you have somebody that you're reporting to, in this instance, General Sibiya had Fani Masemola, who he was responding to, or rather reporting back to. But in case he treats him like he's a non-factor, he treats him like he doesn't exist, he treats him like he's getting his instruction from somewhere else. And now after those dockets and that whole a story had come out about him moving dockets, at whose instruction? He was saying that it was the minister's instruction in the initial series of interviews that he was doing, and then it changed to Fani Masemola, and Fani Masemola kept insisting that he did not give him such an instruction. He came back to the office to only find that he had already started working on disbanding the political killing task team. The instruction of him going all the way to KZN and collecting those dockets, Masemola denied that he told him to do that. But he kept insisting that he did. This is after he had said he got this instruction from the minister. So at the end of the day, now we are wondering, who is General Sibiya reporting to? Is he reporting to the political office of the Minister of Police, or is he reporting to Fani Masemola? Who is his senior? Who is, because even in his court papers, he was challenging the powers of his superior, who, in my opinion, or not even my opinion, it's a fact, it's the National Commissioner. What business does he have with the office of the Minister of Police? That is something that I think I found very, very Very peculiar. So, moreover, the court noted that Sibia's remuneration, employment, or security was not affected by the order. Remember, I saw a headline last week saying that he was saying that his security had been stripped away from him. Those were the allegations that he was making, that he didn't have security anymore. They took away his security. Fani Masemola did a media briefing and they asked him about it, and he said he had not done such. General Sibiya has his full security with him. He did not take any benefits or the security away from him. He just told him to stay at home. And now even the judgment is agreeing that Sibiya's remuneration, employment, or security was not affected by the order. The instruction was no more than an instruction to a senior officer to keep away from the scene of the crime so that he is not further implicated or embarrassed by the investigation, and that the investigation may proceed unhindered. Simple. Hi. Guys, this judgment is giving me something, man. And I even saw, I saw how interested they were in wanting to understand the argument of Sibiya's lawyer. It was not condescending or anything like that. They were seeking understanding. And this judgment is just like, maybe there is hope after all. I don't know. Like this sounds so clear. It's a refreshing judgment to see when most of us had given up hope in this whole legal thing. The court declined to grant Sibiya requests for a declaratory order. It cited muteness and the discretionary nature of declaratory orders. As the investigation was complete and the disciplinary proceedings were underway, the court noted the instruction had already served its purpose. There is no point in granting a declaratory order in respect of something which has already been overtaken by events and which will serve no further purpose. Further, the court rejected Sibiya's argument that the instruction tainted subsequent disciplinary proceedings. In a similar manner, Sibiya's application for an interim interdict was denied. According to the court, he did not establish the requirements for such relief. This is including a prima facie right, a reasonable expectation of irreparable harm, the absence of other suitable remedies, and that the balance of convenience favored him. As a result, the court ruled that Sibiya had no right to halt disciplinary proceedings. Davis stated that the applicant does not have a right to have disciplinary proceedings halted or suspended. The right which the applicant seeks to assert is a self-constructed right. Barry clock it. Guys. Oh my God. They're actually saying that this is a self-constructed right. He made up a right for himself to suit him. There's no such a right. That everything needs to come to a stop so that he can be investigated by the commission and not be investigated by the SAPS. To think that I actually thought maybe he stands a chance, just maybe, because I saw the whole boldness of asking for 3 judges and the bold moves that he was making. But I was like, maybe there's something. Let's give it time to marinate. Let's see where it's going. And even his lawyer sounded like he knew what he was talking about. But these are self-constructed rights, Mtagabao. Go back to the drawing board. So the court also rejected Sibiya's claim that disciplinary proceedings would obstruct the work of the Judicial Commission of Inquiry. Because that's another accusation that he had made, that this parallel investigation that's been run by the SAPS on him will be obstructing the Commission of Inquiry. And after we found out that those findings from the Commission of Inquiry are not going to be binding, it's just the report that the president can have, and he can decide what he decides to do with those reports. If he decides to sit with them in his office, it's his decision. They are not binding, meaning that people are going to risk their lives sharing files and, being whistleblowers and all of that just for the findings to not be binding. General Sibiya wants that process where the findings won't be binding, and he wants everything to stop at the SAPS. He's asking to not be investigated, a parallel investigation to not be run on him as he prepares himself to go to the commission, because he has more faith in the commission and the process of the commission. The court also rejected Sibiya's claim that disciplinary proceedings would obstruct the work of the Judicial Commission of Inquiry. The disciplining of the applicant and the work of the commission are two different things. Even if the applicant's motive for having disobeyed an order may be of interest of the commission. The court found that the balance of convenience favored the commissioner. It emphasized the importance of expediency in employer-employee relations. Davis stated that when one weighs up the possible interdeterminable period of suspension of disciplinary proceedings, should the applicant's contentions be upheld against the benefits of finality to be obtained by expedient disciplinary proceedings, the latter clear trumps of the former. So additionally, the court noted that the commissioner had taken steps to ensure Sibiya's safety. This includes static and transit security, and also that Sibiya had withdrawn the protection team. The South African Police Service has compiled its obligation to provide security to the applicant and will continue to do so in accordance with accepted policies, the judgment read. So the court rejected Sibiya's petition for immunity from adverse costs orders under the BioWatch principle, which shields public interest litigants from cost consequences. It ruled that Sibiya's application did not constitute public interest litigation. He wasn't doing this litigation for the public's interest or for the public or the well-being of the public. He was doing it for himself. It was a selfish act to say, I'm going back to work. So they are saying that the immunity from adverse costs is under the BioWatch principle. That is the BioWatch principle that shields public interest litigants from being their cases being dismissed with costs. So he doesn't fall under this because he's fighting for himself to go back to work. So the court ruled that Sibiya's application did not constitute public interest litigation and criticized his overbroad and unfounded allegations. Now they are calling these claims that he was making against Masemola unfounded and overbroad, meaning he did not back them up with receipts. No evidence. He was just wanting the court to take his word for it just because he is who he is. Allegedly, of course, and that's my opinion. But then Davis stated in this judgment that no law or any state conduct has been challenged on a constitutional basis by the applicant. His assertion was simply that the commissioner had overstepped the bounds of his powers in the context of a simple disciplinary proceeding. Furthermore, Sibiya's allegations of contempt against the commissioner amounted to vexatious litigation, the court said. The making of such allegations without foundation amounts to vexatious litigation. So the court concluded that in the premises, the court declines to grant a declaratory order as claimed by the applicant and finds that the applicant has not satisfied the requirements for an interim interdict. Neither of the two sets of relief can therefore be granted. Hallelujah. It is what it is. This is probably one of the most smoothest judgments, even though I don't have the original copy with me. But what I'm reading from this report coming from Sunday World, it fills my heart. It warms my heart. It gives me hope. There are some judges who are serious out there. You know, not all judges are like the other judge that has been terrorizing us for the last 3 years and has been making us feel some type of way about South African courts. That's clearly my opinion, and I know that he's got fans out there and people that really like what he's doing. But high corner. Now this is what I expect from a judge. I don't want to lie. Like, this was clear, concise, straight to the point, and it helped me understand where his judgment is coming from. Right. So the court declined to grant a declaratory order as claimed by the applicant and fined the applicant had not satisfied the requirements of an interim interdict. Neither of the two sets of relief can therefore be granted. Moreover, the applicant made overbroad and unfounded allegations to the effect that the commissioner was contemptuous of the proposed commission. The making of such allegations without foundation amounts to those vexatious litigation. So the application is dismissed with costs. Costs! That's money. After spending money to have 3 judges, money for a lawyer, money for now costs. He has to pay the costs of the lawyer that represented General Fani Masemola. They also said that Sibia had contended that Masemola was biased against him and that this should be the reason why the commission would be appropriate body to discipline him. And in the judgment it said, nope, this contentious misconstrues the function and the powers of the commission. Moreover, contention impressively subjugates disciplinary proceedings to the proceedings before the commission. So Sibia's attorney, Ian Levitt, said that this was not the end. Whilst our client, he said, respects the decision of the court, and after consultation with our client, it is his instruction to appeal the judgment. General Sibia has money, hey? He's going to appeal after all of that. So instead of paying the costs, he's going to appeal. But a judgment is a judgment and a ruling has been made. We shall wait upon the appeal. But in the meantime, as much energy as he's using to focus on court cases to go back to work, hey, let me not give people advice because now I don't know what I would do if I was in this position. So guys, you let me know what you think in the comment section down below. Let me know. You know, I did my best to try and cover this whole thing in its entirety. You know how I do. I like to get all the sources, as much of them as I can get, and report to you guys in a manner that, you know, shows that maybe I understand what's going on. Maybe I may have gotten some of the stuff wrong or something like that. You guys let me know. And if you have any extra information, don't forget to use the WhatsApp line to, you know, share whatever you may think is necessary and that our Mzansi family should know about. Of course, if it's public information, I don't do exclusives. I don't want to know what nobody else doesn't know. I cover public information. Okay. So until the next one, you guys, we'll see each other next time. And please let me know in the comment section down below what you thought about this entire judgment. It was lit. It was lit. I enjoyed it very much. Let me know what you think. Until the next one, you guys, it's a bye from me.